Good afternoon, everyone. My name is Kristin Maun, and I am the Director of Housing Development and Incentives for the Tulsa Authority for Economic Opportunity, or TAEO. TAEO is the public trust authority that serves as the lead entity for the City of Tulsa in carrying out community and economic development. Thank you for joining us today for a presentation on service, assistance, and emotional support animals. Before we begin today's presentation, I want to share with you two opportunities for landlords and property managers from TAEO for the City of Tulsa. First is the Abode Initiative, which provides information to landlords and property managers about resources and opportunities in the City of Tulsa, such as this webinar. You can receive regular email updates and also reach out to the City and TAEO with questions or concerns that you may have. There is no cost to participating. Just email me at kmaun@cityoftulsa.org. Second is the Gold Star Landlord Program, a free and voluntary program that provides rewards and incentives for landlords and property managers who engage in the best rental practices. Incentives include advertising and promotion as a Gold Star landlord, prioritized processing of applications to the City of Tulsa's Emergency Rental Assistance Program, and access to incentives funded by the Affordable Housing Trust Fund, such as the Tulsa Day Center's Landlord Guarantee Fund. For more information on the Gold Star Landlord Program, please visit www.cityoftulsa.org/landlords or email goldstar@cityoftulsa.org. Today's presentation is by Teressa Webster, Fair Housing Project Director of Advocacy for Legal Aid Services of Oklahoma. There will be an opportunity for questions. Please put your questions in the Q&A section. This presentation is also being recorded and will be made available for sharing online. Thank you, and I will now turn it over to Teressa.
Thank you. Good afternoon, everyone. As stated by Kristin, my name is Teressa Webster. I am the Fair Housing Project Director of Advocacy for Legal Aid Services of Oklahoma. And here we go. Okay, and I will share my camera in 1 second, Kristin. There we go. Okay, so that you all can see me. Okay, well, let's see, well, that's okay. Okay, while we're waiting for my video to come up, I'll begin our presentation on service animals. So as I stated before, I'm the Fair Housing Project Advocacy Director for Legal Aid Services of Oklahoma. And I have been involved in fair housing and assisting individuals with disabilities for several years. And part of what we do is provide assistance to individuals specifically who need assistance with the use of their animals within their housing context. And so there has been a lot of confusion within the housing market about assistance animals, emotional support animals, service animals, and basically what their responsibilities are in reference to those animals. So the first thing I wanted to discuss in this presentation is information about service animals. And so our objectives in this presentation are to, first of all, define what service animals are, and then secondly, to explain what service animals do. And then lastly, I would like to discuss some of the laws in the state of Oklahoma that govern service animals and how those rules apply in the housing context. So first of all, what are service animals? Service animals are defined as dogs that are individually trained to do or perform tasks for people with disabilities. And this is a term that is really specific to the American with Disabilities Act. Service animals are limited to dogs and miniature horses under the Americans with Disabilities Act, or the ADA. If there are dogs that provide just solely emotional support or comfort to an individual with a disability, then they would not be considered as a service animal under the American with Disabilities Act. For an animal, specifically a dog or a miniature horse, to qualify under the ADA as a service animal, that animal has to be trained to provide some type of service or work for the person with the disability. So for example, we may be familiar with certain types of service animals such as guide dogs, seizure alert animals, animals who assist individuals maybe with diabetes to recognize when their sugar levels are dropping, or individuals with PTSD who rely on an animal to help to keep them calm during an anxiety attack. So those are examples of some examples of service dogs or service animals, but that is not an exhaustive list of what they can do. But the important thing is that they provide more than just emotional support and comfort for an individual. They're actually trained to do work or to perform tasks for the person with the disability. For the purposes of determining if an animal is a service animal, that as that term is defined under the Americans with Disabilities Act, the law authorizes a housing provider or an individual to ask only two questions. And the first question is the dog a service animal required for a disability? And if that answer is yes, then the question is, what work or task has the dog been trained to perform? Those are the only two questions that a person may ask about a service dog or a horse, or specifically a service animal. If you are in the business of providing service to the public, or within the context in which I work, providing housing to the public, those are the only two questions that you can ask about a service animal. You cannot inquire into the person's disability. You cannot ask the person who uses the service animal to show you what the animal can do. You are limited to these two questions. And if the answer is yes, then for the purposes of the inquiry as to whether or not the animal is a service animal, then it is complete. So next, I want to talk about service animals and the laws that impact housing that have to do with service animals. Firstly, we've already discussed the Americans with Disabilities Act. And so the purpose of this act is to ensure that persons with disabilities have access to state and local government services, as well as public accommodations and commercial facilities. In the housing context, that could be any place where public individuals are allowed to be within the business. For example, the leasing office, parking lot, just any place that is open to the public. And so your service animal rules are going to apply in those public accommodation areas within the housing complex. And if it's not a housing complex, just any business that's open to the public, any state or local government service that's provided to the public. Then we have the Rehabilitation Act of 1973, Section 504. The purpose of this particular provision is to ensure that qualified persons with disabilities are provided equal access to programs that receive federal financial assistance. A lot of our housing providers, like public housing authorities, some of our, shelters and transitional housing facilities, they may receive federal funding to operate as well. And so in addition to possibly the ADA applying to certain portions of their business, also the Section 504 of the Rehabilitation Act of 1973 will also apply. And then we have the Fair Housing Act, which is going to apply to most residential real estate related transactions. In addition to providing protection to other individuals on other protected class characteristics, the Fair Housing Act requires that persons with disabilities have equal housing opportunities, which would include, but is not limited to, equal opportunities to access housing, to access services, to use housing, and to access and enjoy housing opportunities. in the state of Oklahoma, the other laws that I discussed were federal laws, but for the state of Oklahoma, in addition to the federal laws that I just mentioned, we have the Oklahoma Discrimination in Housing Act, and that prohibits the refusal to rent or lease housing to persons with disabilities who have properly trained guide, signal, or service dogs. Do keep in mind that the Federal Fair Housing Act, of course, provides blanket protection. And so if your Oklahoma state statutes provide protection that is not as great as the Fair Housing Act or your federal laws, then they are going to control. The Oklahoma Residential Landlord and Tenant Act, it prohibits the denial or termination of a tenancy to a blind, deaf, or physically handicapped person because of the guide, signal, or service dog of such person, unless such dogs are specifically prohibited in the rental agreement entered into prior to November 1st, 1985. Also, keep in mind that this law may afford less protection than the federal laws, and if it does, then the federal law is going to control. So the housing provider does not get a blanket pass because our statute may limit that protection. So it's important to know those federal laws. And that's it for our presentation on our service animals. Now I want to talk about the Fair Housing Act, because part of this presentation has to do with emotional support animals as well as assistance animals. And so you will see it was necessary to give the presentation on the service animals specifically so that people would understand the difference, because we see a lot of leases, a lot of rental agreements where, and even advertisements where landlords may use terms that limit protection for persons who have animals that are not pets to just service animals. And so for a person with a disability, that could mean something different than what the landlord actually intends. And so it's important to use the right language, because we don't want individuals with disabilities who rely upon assistance animals believing that they are being excluded from housing opportunities because they don't have a service animal, as that term is defined under the Americans with Disabilities Act. So it's important to use the proper language so that we can ensure that everyone who is being invited to a housing opportunity who may rely upon an animal to be able to use their housing, that they are aware that they are not being excluded because they don't use an animal that is defined under the ADA as being a service animal. So they need to understand that. So I'll proceed with the presentation on, the Fair Housing Act. And this basically will give information about what the Fair Housing is, Fair Housing Act is, what it does, where it applies, and then specific information about assistance animals. They're under what landlords can and cannot do when inquiring about assistance animals, and basically how people can move forward with enforcing their rights to have an animal in their home if that is necessary to help to ameliorate the effects of a disability. So I do want to share that the information that we're receiving or that we're sharing today is we're able to do that as a result of funding that we received from a grant from the U.S. Department of Housing and Urban Development. So they do sponsor our Fair Housing Act education activities. They don't specifically author what we say, but they do assist us with getting the message out to our housing providers and the lay public about what their rights are under the Fair Housing Act. So we're going to learn about the history of the Fair Housing Act today, and also what housing discrimination means specifically within the context of providing housing and preventing housing discrimination for persons with disabilities. And then also we may discuss some of the consequences that may arise from violating the Fair Housing Act. Interwoven into this presentation, I have also included some case examples that I'll give some simple facts about to show you how specifically persons who needed assistance to use an animal or to get a reasonable accommodation in their housing and who were denied, what those consequences were to the landlords for not granting those accommodations. So first of all, we'll talk about the Fair Housing Act. The stated purpose of the Fair Housing Act is to provide within the constitutional limitations for fair housing throughout the United States. So this is a federal law and it applies in all 50 states within the United States, as well as all of its territories. And it applies to anyone who lives in the United States. It's not just applicable to citizens, but it's applicable to anyone who resides in the United States who seeks a housing opportunity. In your practice or in providing services to individuals, you may encounter people who, may be here under some other arrangement. Maybe they're here as an immigrant or as a resident or an asylee, and they may be disabled and they may need assistance with obtaining access to housing services. Just know that the Fair Housing Act is going to apply to them and they are not excluded just because they are not citizens of the United States. The intention of the Fair Housing Act is to protect individuals from discrimination when they are renting or buying a home, when they're getting a mortgage, seeking housing assistance, or engaging in other housing related activities. And this is a statement by HUD. What HUD says about the Fair Housing Act and individuals' rights to access under this law is very important because HUD is the agency that has authority under the Fair Housing Act to enforce this act and to interpret it. And so if any individual finds themselves having to go to court to enforce a right to fair housing, the court will give great deference to statements made by HUD and also HUD's interpretations of the Fair Housing Act when making a decision as to whether or not a person has suffered a violation of the act by a housing provider. These are the areas in which the Fair Housing Act will apply. So it governs transactions that concern the rental of housing, sales of housing, lending transactions related to housing, insurance that's related to housing, and that would include, but not limited to, homeowners insurance as well as renters insurance. It pertains to zoning ordinances and laws that cities or states may enact for the purposes of determining housing rights. It affects or it governs advertising. It applies to public housing as well as subsidized housing. Many people believe that because the Fair Housing Act, is a federal law that it does not apply to private housing, but it does. And then it's going to apply to most residential real estate related transactions. So, for example, I mentioned that it applies to lending. And so a lot of lenders or, a lot of lenders may try to defend an act or practice that could be considered as discriminatory under the Fair Housing Act on the basis that, it only applied to the initial loan transaction. But because of the fact that it applies to most residential real estate related transactions, it could also apply to the servicing that occurs after the loan itself has been finalized. And so just know that, there is a very broad applicability for this particular act when it comes to housing related transactions, because the goal of Congress in enacting the Fair Housing Act was to ensure that housing discrimination was stopped as far as the Constitution would permit them to act to stop it. Next, we want to discuss that the Fair Housing Act applies to dwellings. I hear an animal in the background, which is appropriate since we're doing a service animal / assistance animals and emotional support animals presentation. So what is a dwelling? So the Fair Housing Act applies to dwellings, and this definition is specific, and it's important to know if a dwelling is in place, because of course, if there is not a dwelling, then you may not have fair housing rights that apply, and you may have to look to another law for some type of redress. So a dwelling is any building, structure, or portion thereof which is occupied as or designed or intended for occupancy as a residence by one or more families in any vacant land which is offered for sale or lease for the construction or location thereon of any such building, structure, or portion thereof. The Fair Housing Act defines that term families to include just one individual. So, don't be misled by the fact that if maybe you have a client who believes that they have experienced some type of discrimination, but they're just one person and they don't have a group of people living with them. Don't think that they're excluded because they are not a family, because the Fair Housing Act does define the term family as just one person. So you have to have at least one person to have a family and for the Fair Housing Act to apply. Dwellings are also a place where people have a reasonable expectation that they can return and live and dwell there. So we're not looking at a place where a person is just visiting and it's clearly established and agreed upon that they are a visitor. We're looking at permanent occupancy versus temporary or transient occupancy. Some examples of multifamily, some examples of dwellings would include multifamily housing, single family homes, mobile homes, vacation homes, long-term homeless shelters. I had a question from a presentation that I did earlier this week as to whether or not this definition includes transitional housing. And the answer is it depends. If the transitional housing agreement allows that person to basically walk away from the handshake agreement, saying with the understanding that they're going to return there over and over again as a residence, then yes, that would be a dwelling and the Fair Housing Act would apply. So next we want to discuss who is a person. It's important to understand this definition because persons are, natural people, but they could also be unnatural people such as organizations, corporations, they could be cities, they could be legal representatives of natural persons, mutual companies, trust organizations, they can be non-person entities. And it's important to know that because not only can people violate the Fair Housing Act, but also the people, persons as defined under the Fair Housing Act can also be aggrieved. So the fair housing rights could extend to an individual, or they could extend to even an entity that represents individuals who are victims of unlawful practices as are defined by this. So an aggrieved person includes any person, as previously defined, who claims to have been injured by a discriminatory housing practice or who believes that such person will be injured by a discriminatory housing practice that is about to occur. So again, you can have, natural individuals who have been harmed. You could have cities who have been harmed as aggrieved parties to violative Fair Housing Act practices. You can have organizations that represent individuals who are disabled who could file Fair Housing Act claims for violations of this act on behalf of the people who they serve. So let's talk about what housing discrimination means, and we're speaking specifically within the terms of disability. So under the Fair Housing Act, the term disabled or handicapped is defined as a person who has a physical or mental impairment which substantially limits one or more of such person's major life activities. Major life activities could mean anything, including but not limited to maybe a person's ability to breathe, their ability to see or to walk or hear or think or eat, work, or care for oneself. Congress has defined this in the regulations, but they have not provided an exhaustive list of what it means to be handicapped or disabled for the purposes of Fair Housing Act. Secondly, a person could be a disabled individual if they have a record of having such an impairment. And then lastly, if they are regarded as having such an impairment, they would be considered as disabled. Now, under the Fair Housing Act, a person who has a record who is recovering from substance abuse would be covered as a person with a disability, but the term does not include individuals who are currently addicted to or illegally using controlled substances. But if a person is in recovery, then they are considered as a person with a disability as well. Under the Fair Housing Act, it is unlawful conduct to make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on race, color, sex, handicap, religion, familial status, or national origin, or to make, print, or publish, or cause to be made with the intention to make that preference, that limitation, or discrimination. As housing providers engage in communications with persons with disabilities, it's important to not make statements that the person who is reading or hearing that statement perceives as a discriminatory statement that could express a limitation, a preference, or other type of discrimination against them because they have a disability. Earlier I mentioned statements about limitations on persons who use service animals versus those who have other types of animals that assist with disabilities. That would be covered. Those statements would be covered under this provision. And if those statements are perceived by the person who has heard them or who has read them as being discriminatory, then that could be a violation of the act. And that's why it's important to know, basically in addressing animals that are used in association with the person's disability, it's important to know how to phrase the language. It's also unlawful under the Fair Housing Act to represent to any person because of their disability, as well as any of the other protected classes, that they are not able to inspect a unit that is available for sale or rental when other persons who don't have disabilities could do that. And that is typically done in the when a person with a disability, for example, may ask to see an available unit. And if the housing provider says, well, we don't have any ADA compliant units, that presents to the individual with the disability that they are not allowed to see a regular unit, that they're only allowed to live in units that are ADA compliant. So that would be a denial of an inspection of an available unit based upon disability. And again, that would violate the Fair Housing Act. And then also inducing individuals to move from housing because of maybe people with disabilities entering into the neighborhood. We have a lot of sober living homes and other types of group homes that are being built for the purposes of helping individuals with disabilities to basically re-enter society and to live on their own. There are people who may try to discourage other individuals from living in neighborhoods where the group homes are, or sober living homes are because of who lives there. Well, that would be an example of a violation of this section of the Fair Housing Act, and it is considered as unlawful conduct. Now, I want to switch over into the specific provisions of the Fair Housing Act that could, in fact, impact individuals who rely upon assistance animals to use their housing. In 1988, the Fair Housing Act was amended to include additional protections for persons who have disabilities. And so those provisions are found under Title 42, Section 3604F. And there are several sections of Section F that are going to apply. So first of all, it's unlawful to discriminate against a person in the sale or rental of housing by making that housing unavailable to them or denying the housing to them because of their disability. If they are the person who is actually going to purchase or rent the home because of the disability of any person that's going to reside with them or who they intend to reside with them in that home after it is sold, rented, or made available, or for making the housing unavailable to any person because of their association with another person who has a disability. Some examples, there would be a refusal to sell or rent a house to a person because that person has a record of drug usage, but they're not presently using drugs. As I stated before, persons who are recovering from substance abuse, they are considered as persons with disabilities. So they are entitled to equal consideration without regard to that record when they are seeking housing opportunities. Refusals to negotiate the price of a dwelling because a person may be mobility impaired, or not having housing that's accessible to individuals with disabilities or persons with mobility impairments, that would also be an example of a discriminatory act or practice that would violate this section of the Fair Housing Act. Under Title 42, Section 3604 F2, it makes it unlawful for a housing provider to use different terms and conditions or privileges of sale or rental for persons with disabilities, those who will reside with them, or for those who are associated with them in respect to that housing transaction. An example would be this case here that didn't occur in Oklahoma, but we have seen like practices in Oklahoma and have challenged them. But in this particular case, HUD versus Country Manor Apartments that occurred in 2001, there was a landlord who conditioned individuals, well, he conditioned the rental of property to individuals who relied on wheelchairs to them purchasing personal liability insurance. So other individuals who did not have these mobility impairments were not required to purchase the personal liability insurance, whereas the persons who use wheelchairs were. Well, that was a different term and condition that violated the Fair Housing Act. We saw in the state of Oklahoma where there was an individual who, or an individual landlord who actually required individuals who use motorized wheelchairs to purchase, to pay a $1,000 security deposit because he basically stated that wheelchairs would wreck the walls. And so no other individual or no other renters were required to pay that $1,000 security deposit, only people who use motorized wheelchairs. And so that would again be a term or a condition that was different based upon disability, and it would constitute discrimination under the Fair Housing Act. The Fair Housing Act also requires, or the Amendments Act requires, housing providers to permit persons with disabilities to make reasonable modifications to existing premises that are occupied by them or that will be occupied by them if the modifications are necessary to afford the person with a disability the full enjoyment of the premises. And so a modification is a change to the actual physical structure. It could be to the interior, it could be the common areas on the premises, but it is a change. It's where something is either being added or taken away so that the person with the disability can fully enjoy the premises or have an equal opportunity to do so. For reasonable modifications, a landlord can require, when it is reasonable, for the person with the disability to restore the interior of the unit as a condition to grant the permission to make the modification. An example of that would be if the person with the disability requested to remove cabinets from the bathroom or to remove cabinets in the kitchen so that they could fully use the kitchen, either because it was too small for them to turn around in their wheelchair or because they couldn't access it because of a wheelchair. And under those circumstances, the landlord could condition that, the granting of that modification for the removal of those cabinets, would be granted if they would agree to put them back when they moved out. There are some times when a change to the interior may not be reasonable. It may not be reasonable to condition the change of the interior on the restoration when the person leaves, because it's just not reasonable. For example, if a person had to widen a doorway for the purposes of having access to it because the wheelchair couldn't fit through the doorway, it would not be reasonable under those circumstances to require the tenant then to restore the wall when they left. So reasonableness is the key. In granting reasonable modification requests, there has to be a nexus between the disability and the requested modification. So the person who's making the request to make the change to the premises has to be able to demonstrate that they in fact do have a disability and that the requested modification is connected to granting that person the opportunity to fully use and enjoy the premises if the modification is granted. So if the landlord cannot tell whether or not the person has a disability or that the modification is somehow connected to that disability, the landlord can request verification of the disability. In making that request, the landlord cannot require, in making the request for verification, the landlord cannot require the tenant to present a letter just from a doctor. So under HUD's guidance, when a landlord is, permitted to request verification, the landlord can, really it's reasonable to accept it from any person who has intimate familiarity with the person's disability and their disability related need. That letter or the verification could come from a doctor, but not necessarily is it required that it comes from a doctor. It could come from a caregiver or just any person who has, knowledge of the person's disability. They have intimate familiarity with it and they're able to articulate why the needed modification is being requested. And if that's provided, then that's sufficient for Fair Housing Act purposes. The landlord can require that the modification be made in a workmanlike manner, depending on what the request for the modification is. Sometimes it may not be reasonable to ask for that, but if the person is, making a structural change that could cause other individuals to be, their health and safety to be jeopardized, then it would be reasonable for the landlord to request it to be made in a workmanlike manner. The landlord can also request that the tenant place money in escrow to pay for the restoration of the interior after the person leaves, and the disabled person can make the request at any time during the tenancy. So they can request it at the very beginning of the tenancy when they're applying for housing. They could request it after they move in, if that's when it becomes necessary. So we're looking at the time when the need arises and when the person is aware of it, and that's when they can make the request for the modification. And these are some examples of reasonable modifications. A request to add a ramp, for example, to a main entrance of the building would be an example of a modification. If a person who is visually impaired requests to install a voice-activated atmospheric control, like a voice-activated thermostat, that would be an example of for a reasonable modification. If a person were to request to have doors widened so that they can get a wheelchair through, again, they're modifying the structure of a unit or of the premises. And so that would be a modification. And then I mentioned before, requests to remove cabinets under a sink so that the person could actually reach it if they're in a wheelchair. So those are some examples, not at all an exhaustive list, but just examples of modifications. Under Title 42, Section 3604, F3B, this has to do with reasonable accommodations. And this is really where you're going to encounter your request for assistance animals. So a reasonable accommodation is a request to have a change made in rules, policies, practices, or services that a landlord or other housing provider may have when such accommodations may be necessary to afford such a person an equal opportunity to use and enjoy a dwelling. So for a reasonable accommodation, the person is not really asking to change the structure or to do any physical changes to the unit. They're asking for the landlord or the housing provider to change a rule. And so under HUD's statements concerning reasonable accommodations, it's sort of kind of like it was with our modifications. There has to be a nexus between the requested accommodation and the person's disability. So the person just needs to be able to demonstrate that they do have a disability and the request that they're making is connected to that disability. Usually, the housing provider does have a duty to grant the accommodation. There are very rare exceptions when the landlord or housing provider does not have to grant the requested accommodation. Now, under HUD's rules and interpretations of the Fair Housing Act's provisions concerning accommodations, it really is the responsibility of the housing provider to grant the accommodation and to pay for whatever expense, there is associated with granting that accommodation, because it usually does not cost a lot of money to change a rule. And so really, the accommodation should be granted unless it will result in an undue financial or administrative burden or result in the fundamental alteration in the nature of the programs and services provided by the housing provider. If the landlord or housing provider can't show that there's an undue financial or administrative burden or some other type of fundamental alteration to their programs and services, then they're required by law to grant requested accommodation unless the person cannot support the need for that accommodation with, the disability and the disability related need. The landlord can request, or the housing provider can request verification for the disability and the need that's requested, that supports the requested accommodation if it's not readily apparent. So if the person, for example, were in a walker and they were using a walker because they have a mobility impairment, and if they asked for a closer parking space to their unit, and the landlord can see that the person has walking disabilities, it would not be appropriate under those circumstances to request verification. In the context of assistance animals, if the landlord can readily discern that the person has a visual impairment and that they need an accommodation to a no pet policy to have their guide dog in the unit, it would not be appropriate under those circumstances for the landlord to make a request for verification when they can readily discern the need for the accommodation. If the housing provider is unable to grant the requested accommodation, he or she must engage in an interactive process to arrive at a suitable alternative. So it's not okay to say, well, we just can't do it and that's the end of the conversation. They have to propose an alternative. And a person requesting an accommodation can do so at any time during the tenancy. If that request can be made when they apply for the housing opportunity, as well as after they take possession, and even up through the point of termination if it's necessary. So I have an example here, and this was an example. We talked about the parking space where we had the plaintiff in this case, she had walking disabilities, a mobility impairment. She did ask for a closer parking space to accommodate her, and the landlord refused. And as a result of the landlord refusing that, she sued them, and she was awarded $20,000 for that refusal to grant that accommodation. So that's why it's important to know that granting reasonable accommodations is required unless they cannot be. Because of the three reasons that I mentioned. And even if they can't be granted, then the housing provider has to engage in that interactive process in order to not be held liable of the violation of the Fair Housing Act. So next we'll talk about assistance animals. We, of course, have in our title the phrase assistance animals. And so assistance animals are a term that is, I would say, probably unique to the Fair Housing Act. The Fair Housing Act does not specifically mention that term, but HUD in its interpretations of the Fair Housing Act has actually provided this guidance concerning assistance animals and the need to grant reasonable accommodations for individuals who use them. So HUD defines the term assistance animals as an animal that works or provides assistance or performs tasks for the benefit of a person with a disability or provides emotional support that alleviates one or more identified symptoms of the symptoms or effects of a person's disability. It's important to know that assistance animals for Fair Housing Act purposes are not pets. They are an extension of the individual, similar to a wheelchair, a walker, a cane. If the person relied upon oxygen, the oxygen tank, that's how assistance animals are viewed under the Fair Housing Act. A person with a disability may need more than one assistance animal because they may have more than one disability-related need. We were told of a story where an individual, she had to have two emotional support dogs. One was her comfort animal or her emotional support animal because he helped her to not be depressed. But the other, her doctor prescribed, basically recommended that she get a puppy because the comfort animal was not active. It was an older animal. And so the puppy actually would help her to get out of bed and to get moving so that she wouldn't just sit and be depressed in the in her bed because of whatever circumstance it was that she had going on. So, she needed 2 animals. And so we may encounter individuals who may have a need for more than 1 animal because they may have more than 1 disability related need. And as long as the person who is making the request can verify that they have this disability and that they have the disability related need for both animals or more than 1 animal, then the request to have those animals in their unit should be granted. Assistance animals don't need special training to provide assistance to persons with disabilities. So this is different from the specific definition that I gave you for service animals, because those do have to be trained, but for assistance animals purposes, they don't require training. They don't require certification. They don't, the HUD doesn't require them to be registered. They don't need any of that. So it's important to know that as well, because we have a lot of housing providers who require their disabled tenants or disabled prospective tenants to have their animals certified or to have them registered with the service animal registry as a condition to waiving or changing the rules and granting reasonable accommodations for them. That is not something that HUD requires. And as advocates for individuals with disabilities, it's important to know that. Now, these are some examples of assistance animals. The term assistance animals for Fair Housing Act purposes includes all of these types of animals, not just dogs or horses. So an assistance animal can be any animal that provides the support, that performs tasks, that aids a person with a disability in ameliorating any of the effects of that person's disability. So that could include service dogs and horses. Could also include therapy animals, emotional support animals, and comfort animals. So all of the animals that assist persons with disabilities are included within the category in the class of assistance animals for Fair Housing Act purposes. I have an example here. This case was Chunasetti v. Twin Oaks Apartments. This was also an Oklahoma case that was filed in 2018. In this case, Ms. Chunasetti had a schnauzer. And the landlord had a requirement that in order for the landlord to waive the pet deposit and to waive the pet rent, the animal had to be registered with a service animal registry. Ms. Chunasetti, subsequent to beginning, accepting occupancy and taking possession of the unit, discovered that that requirement of the landlord actually violated the Fair Housing Act. And she basically tried to work with the landlord to get her rent back and also to get back the pet deposit of $350 that she paid. And the landlord refused and took adverse action against her. So she filed a lawsuit in the Eastern District of Oklahoma, and the landlord's refusal to grant her request to refund the pet deposit and the pet rent and to stop retaliating against her because of her animal, it cost that landlord $35,000. So again, very expensive for denying that, very expensive lesson for denying that reasonable accommodation request for her assistance animal. And then we have section 3617. It makes it unlawful to intimidate, to threaten, or interfere with a person for having enjoyed a right that's protected under the Fair Housing Act. And that would be inclusive of making a request for an accommodation to any type of pet rule or policy concerning an animal under the Fair Housing Act. And so doing, it is, if a person does engage in any of this conduct, it would be a violation of the act. It's very expensive to do that as well. And before I continue talking about coercion, intimidation, threatening, and interfering with rights that are guaranteed under the Fair Housing Act, I also want to just go back to talking about requirements for dangerous breeds. HUD has issued guidance when individuals who rely upon assistance animals, when they may, request an accommodation to have an animal that is from a quote unquote dangerous breed. HUD requires that the landlord do basically a case-by-case analysis, and they are to do a specific inquiry into the animal itself. So they can't just exclude because the animal comes from a dangerous breed. They have to look at the specific conduct of the animal. They have to look at the specific threat that the animal poses. And so if the animal has no propensity to, threatening the health or safety of other individuals as having been demonstrated by that animal's history, then basically the animal should be allowed. We see this a lot with dogs that come from like the pit bull breeds. There are a lot of exclusions for those animals just because they come from dangerous, what is deemed as a dangerous breed. Under HUD's regulations or HUD's interpretations of the Fair Housing Act's requirements to grant reasonable accommodations, it is not lawful to just exclude an animal just because the animal is from what has been deemed as a dangerous breed. And so pit bull exclusions would not be okay. It would be a violation of the act unless that dog had specifically demonstrated some type of dangerous propensity. Maybe it has bitten someone or otherwise destroyed property belonging to other people. Then a ban would possibly be justified. But just to do a blanket ban because of the breed of the animal is not okay. And then also when a reasonable accommodation is requested for an assistance animal, HUD requires, once it has been demonstrated that there is a need for that animal, that any policies that restrict size or weight restrictions, that also be waived, and as well as any pet deposits or pet rents. And so really, when a person is making an analysis as to whether or not an assistance animal should be, or request for an assistance animal should be granted, they can only ask two questions. First of all, does the person have a disability? And second, does the animal that's in question help to meet a disability-related need? And so if the answer is yes to both of those questions, then the landlord has a duty to grant, or the housing provider has a duty to grant the requested accommodation for that specific animal. So my example here on retaliation has to do with an individual who made a request for an accommodation to her landlord, and actually made a request for an accommodation and a request for remediation of her premises because of her disability. And the landlord was basically very slow in making that repair until she became harmed. She actually injured herself very badly and complained. And after she complained, the landlord made the repair, but after making the repair, the landlord began taking steps to make housing unavailable to her. And as a result of the landlord doing that, she filed a lawsuit. And after filing that lawsuit, she recovered $100,000 from the district court in Oklahoma, the federal district court in Oklahoma, because of that retaliation. So it's important, again, to recognize, to recognize these laws, to recognize the terms, to be aware of when our clients have a right to request accommodations to any pet rules because of their disability related needs, and to know when those rules are being, and to know when their rights are being violated so that we can assist them with enforcing rights under the Fair Housing Act and any other laws in the state of Oklahoma that would assist them to having access to housing. So that is all that I have. And I'm going to ask, are there any questions?
Teressa, can you hear me?
Yes, I can hear you.
There are two questions in the Q&A section. Are you able to click on those, or would you like me to read them to you?
I can see them. You can read them and I'll answer them if you want.
Oh, no. I would read them to you, but okay. If you couldn't see them. So I'll mute while you answer. Thank you.
Okay. All right. So the first question is the requirement that the letter come from a doctor or a qualified medical professional? Okay, and so the answer is no. So I have an Aisha Youngblood Blakely would like to answer this question live. Okay, so the answer is no. And I know that we have some provisions in the in our state statute that talks about who the letter can come from, but under the Fair Housing Act, there is not a requirement that it comes from a doctor or a qualified medical professional. The requirement is that it comes from someone who is intimately familiar with the person's disability and their disability-related need. And I have an Aisha Youngblood Blakely. I don't know how to unmute you, but I think that you.
That was me just clicking that you're going to answer it live.
Okay, all right, thank you. Okay, so that is the answer to the question. Usually when I have clients who I am making a request for, I will seek some type of letter from a medical professional, preferably a doctor, because I am an attorney. And so usually I am trying to build a case with unrefutable evidence or irrefutable evidence. And so I will go to the person who I know, if we put them on the stand and a jury says, they didn't really prove that they needed it. It's going to be really hard to dispute the doctor who treats this person if the doctor says they need it. And so usually I will rely on the doctor, but it's not required. HUD basically says that, any person who has intimate familiarity with a person's disability and their disability-related need can provide that verification to the landlord. Okay, and then we have another question, which is, I have my other question. I read somewhere that the Oklahoma Attorney General in 2005 had an opinion that in Oklahoma that municipalities cannot set dangerous breeds. If landlords set dangerous breeds in their policies here in Oklahoma, would that be a violation, or can they set dangerous breeds even though it is not a state or municipal ordinance? Okay, that's a loaded question. So I'm going to tell you this. Parties are free now. An individual who is acting privately is different than a municipality. And so I'm not saying in this training that a landlord can't have a rule that says we won't have pit bulls, we won't have German shepherds, we won't have this or whatever. What I'm saying is that if a person with a disability makes a request to live there and the animal that they rely upon as an assistance animal is an animal from a dangerous breed, when the person makes the request for an accommodation to that rule, the landlord has to grant it. So, and I hope that answers your question. So, and I will also say that our municipalities and, our cities, which, will be municipalities, our towns, they may have their different ordinances, but they are also required to follow the Fair Housing Act. And so if a person with a disability utilizes an animal that may not be permitted by the city, that person can make a request to the city for a variance or a reasonable accommodation. And the city is also required to follow the Fair Housing Act's requirements for that. So I hope that answers that question. I will also make one additional statement. Sometimes landlords will have those rules because they have insurance policies that will not cover certain breeds of dogs or animals if they are on the premises. And so if that in fact does occur, and the person who has a disability needs to be able to have access to housing, but may be precluded or excluded from housing because they rely upon an animal, the landlord or the person with the disability can also make a request to the insurance company, because the Fair Housing Act also regulates homeowners. The insurance industry as far as it goes with housing related transactions. So the insurance company would also be required to follow the Fair Housing Act. Okay. So are there any other questions? All right, well, thank you so much for your time. And again, I'm Teressa Webster. If you have any further questions, I'm here at Legal Aid. And so we're happy to help. We have a website, legalaidok.org, where we have plenty of information about the fair housing laws as well. So thank you so much for your time.
Thank you everyone for participating. This webinar has been recorded and it will be posted to the City of Tulsa's YouTube page. If you have any follow-up questions, you can reach out to Teressa. I also encourage you, if you have questions about the Abode Initiative or the Gold Star Landlord Program, you can reach out to me at TAEO. Again, my name is Kristin Maun and my email address is kmaun@cityoftulsa.org. Thank you so much and have a good afternoon, everyone.